question, let me know. But I want you to be mindful of Socrates. If you want to participate, I might have a question or two this evening that I want to ask you. So we will be in the room. Prof. Blackmore, just hit join and just wait for a question if I have one. But so we're going to talk about negotiation. With me, it's very critical. Okay, everything you do really does relate to some type of negotiation. For us, it's going to be that process of submitting and considering offers back and forth from the other side until we get to something that is acceptable for the two of us. And so it's like a daily life thing. Like the other day when I was talking to Mr. Dalton, I went up to him and I said, okay, what if I come by your house and I want to buy your car? It's just that simple. Any kind of thing that could come up, and let me just tell you, it is going to be linked to any type of thing that you do in your practice. I don't know if you remember, but I was telling you about a situation where we had this hair on fire request for admission situation in our office, and somebody forgot to put the discovery on the calendar. And so then we realized it when we got the motion from the other side to deem those admissions admitted. And so, I was working with one of the attorneys in the office because this was really his case, and I was just, he was just completely fumed about it. And you have to realize that there is a middle line in every situation. You have to know what your bottom line is, and you have to kind of think about where you can give a little bit before you pick up the phone. There are going to be types of negotiating styles that you want to employ. And so I said to that person, okay, hey, let's think tactically about this, okay? The judge is probably, going to realize the mistake. So, he was asking for $1,500 in damages or whatever. So let's determine what amount, we can accept or, based on the situation. And we were able to get out of it for $0. And I'm convinced it was because of negotiation, because of the situation, because of the law. These types of things you'll be able to see when we start to work on the negotiation plan that we're going to work on. And so then there's those key concepts that we want to be mindful of, like a position. It's a demand, in the beginning of a situation, what I would say when you get the plaintiff's complaint, and it usually says in there for an amount not greater than $1 million, some crazy number, that's going to be their first outlandish demand, so to speak. And sometimes they're not going to want to bid against themselves until there's some type of a first demand coming from the other side. And then we want to be mindful of the interest of each party. Then there are going to be those standards, the objective way of measuring that some of the terms or of the agreement. And then our book and our author talks about the best alternatives, what I would want to call your best case scenario, and then your worst case scenario. What is this going to be like? Dreadful. You want to be mindful of these things and be ready to negotiate within those parameters. And then there are those bargaining styles. Your distributive bargaining is your negotiation where one party gains is another party's loss. We're going to find that maybe we want to maybe not employ that in most case scenarios. And then there's your interest-based bargaining, your negotiation where you want to consider the interests of the parties, and then your reframing. Your reframing is a restatement of that party's position, which at some point, like I said, when you start off with that complaint, that's $1 million. It's not going to be $1 million probably at the end of the day. And then your reservation, like I talked about, your bottom line. And then your anchor position, that position that I was talking about, a position stated by the one party to influence the other party, is usually that first offer, that first outlandish, insulting first offer. And we will learn throughout this process that I found that you have to be careful, because you can spoil the relationship, which is a very important part of negotiating, which I found requires some amount of trust. The other party definitely, depending on the facts of the case, probably, hate your guts. But there has to be some trust to know that you're going to negotiate in good faith. If you come in with $500 million, and then the other party, and then you come back with a $5,000 offer, that's going to spoil the well from the beginning. And so these are the kinds of things that we want to be mindful of. Also, we want to be mindful of always the client's goal or goals. What the client wants to close the deal. The best deal they can get, obviously they're going to want that, and they're going to want to pay the least amount of money, and they want to be comfortable thinking that you will protect their interest at all costs. Now, we're going to see some pitfalls in our example today. And then you have to have a deep understanding of the client's interests. Again, that's going to come from understanding the client's goals. Remember, we talked about that mostly coming from an aspect of being able to synthesize the pertinent or relevant facts and being able to key down and bear down on what the client wants. And then this right here, to me, remember that Target situation where 5 years running, the Target is thinking that they're going to build a store, and that store is still sitting out there in Hollywood unbuilt. A lawyer must counsel and help the client to make good decisions, because people are going to be looking back and they're going to be like, well, wait, what happened? So that's going to bring us to our tasty little situation here today. We're going to look at this Cosby case, because there were some situations where...
I'm Michael Smirkanish. We start with breaking news, my exclusive story about comedian Bill Cosby and evidence that I believe jeopardizes the criminal case against him. You'll recall that just a few weeks ago, the famous comedian was finally hauled into court in suburban Philadelphia to face charges for sexually assaulting Temple University employee Andrea Constand. This after at least 50 different women, you see many of their faces here, all had come forward to say Bill Cosby had molested them. I have learned that this case, the only criminal charge that Cosby has ever faced, might soon fall apart. I have obtained a document that no other journalist has that could blow the case up. I talked about it a bit last night on AC 360, but now, new information. So let me back up and tell you the story. Back in 2005, the then District Attorney of Montgomery County, Pennsylvania, Bruce Castor, was investigating Andrea Constand's case. Castor had said he wanted to prosecute Bill Cosby, but believed he did not have enough evidence to sustain criminal charges beyond a reasonable doubt. Still, he thought that Constand might get justice in a civil suit, and he claims he made an unusual deal to create an atmosphere where she could get that justice. The DA told the comedian's attorney, essentially, I won't prosecute your client if you promise that he'll testify fully in a civil case. Cosby's attorney allegedly agreed. It was a deal. In the deposition, Cosby admits he had sexual relationships with at least 5 women outside his marriage, gave prescription sedatives to women he wanted to have sex with, and tried to hide affairs from his wife. Cosby says he gave Constand 1.5 tablets of Benadryl, an over-the-counter antihistamine that can cause drowsiness, to relieve stress. He said that the sex and drug taking were always consensual. Why would Cosby testify so openly? Because allegedly he believed it would never be used against him in a criminal court. The civil case against Cosby was settled, and the deposition remained sealed for many years, but then, last year, a judge decided to release a transcript of it. And the explosive charges Cosby faces now are largely based on that transcript, which we now know could very well be thrown out of court when the case has a hearing on February 2nd. In the last few days, I obtained an email. This email that I confirmed was written by ex-DA Bruce Castor to his successor last year, 3 months before the charge against Cosby. Only those involved in the case have seen this email until now. It's the only clear record of the deal that was made promising not to prosecute Bill Cosby. And here's an excerpt. Castor wrote, "I can see no possibility that Cosby's deposition could be used in a state criminal case because I would have to testify as to what happened, and the deposition would be subject to suppression. I cannot believe any state court judge would allow that deposition into evidence. Knowing this, unless you can make out a case without that deposition, and without anything the deposition led you to, I think Cosby would have an action against the county and maybe even against you personally." Bruce Castor has been subpoenaed to appear at the hearing on February 2nd, at which time I believe the case could fall apart. Joining me now, former prosecutor and defense attorney Mark O'Mara, Philadelphia defense attorney William J. Brennan, and defense attorney Areva Martin. Mark O'Mara, what could you as a defense attorney do with the information that I've just provided?
Well, there's no question I would go to a court and say, look, Judge, we have this agreement. It's done. It's an immunity agreement, which means you simply cannot use my client's testimony against him. It is the only reason why he testified was because of the agreement, and it needs to be suppressed. Now, I'll tell you, Michael, there are a lot of problems with the way Bill Cosby's lawyers handled or failed to handle this 10 years ago. Why this agreement was not ironclad and in writing, kept away in a lawyer's safe somewhere to use for a precise time like this, I have no idea. Plus, immunity agreements, even if they existed, are not ironclad, they're not 100%, and there's a lot of ways this information can still be used against Bill Cosby if he doesn't act appropriately under that supposed agreement.
Okay. So far, are we clear? We're dealing with here really two supposed agreements. Okay, I just want to make sure. And are there any questions about this amount of information so far? Okay, so we're dealing with a possible agreement with Andrea Constand that seems like it went bad, and then there seems to be an agreement supposedly with the DA's office. So this is right with issues regarding getting to the ultimate client goal, and I think that some people missed the mark on protecting that client goal. Are there any questions so far?
Bill Brennan, give me the view from the ground in suburban Philadelphia on this issue of immunity, because I know that the current DA says, hey, there's a protocol that one must follow for immunity, but immunity is provided by a court. I think this is Castor in the email saying, I exercised my DA's discretion.
Absolutely, Michael. I think to call this an immunity agreement is really to play into the hands of the current district attorney, because in his response, he says there are formal protocols for immunity agreements, and they weren't followed here. This is a promise by the former district attorney who had the authority to bind the Commonwealth in perpetuity, not to prosecute. It's very well, I agree with Mark.
I want to pause on that. Last week we had a question about who is it that is to sign the agreement, and there were some facts that were given to us. They may not have been like clearly saying this is the person that's going to sign the agreement, because now we're at a point now where we're going to be learning how to draw inferences from certain information. And so they use that word again, bind. Remember, it has to be someone signing the agreement or entering into the agreement that has the authority to bind that particular party.
It is curious that this was not reduced to writing, but it's a very strong possibility that Mr. Cosby may not have wanted a quote-unquote immunity agreement. Immunity infers to the public that you have criminal exposure and that because of the largesse of the prosecutor, you're getting a pass on your crime. And let's go back to 2004, 2005. Dr. Huxtable was the most popular guy in America. I don't think that he wanted an immunity agreement. He wanted what he got, which is a binding promise not to prosecute. And he gave up a valuable right in testifying under oath at the civil deposition. That bell can never be unrung, and a subsequent prosecutor should not, and hopefully will not, be able to invalidate the agreement that Mr. Cosby made.
Ariva, I know this is complicated for non-lawyers, so let me walk through 2 steps, and then I'm eager to hear what you have to say. A petition was filed last Monday by Cosby's lawyers. Here's an excerpt. The Commonwealth, through then District Attorney Bruce Castor, promised in 2005 that Mr. Cosby would not be charged in connection with these allegations in exchange for Mr. Cosby giving testimony in the complainant's civil case. And then this line, which I've highlighted, Mr. Castor reminded the District Attorney's Office about that agreement in 2015 before these charges were brought. And Ariva, there was no further explanation as to how former DA Castor had reminded them. Now we know he did it in writing on September 23rd, 3 full months before they charged Cosby. And here's another excerpt from the email that he sent. With the agreement of the defense lawyer and Andrea's lawyers, I intentionally and specifically bound the Commonwealth that there would be no state prosecution of Cosby in order to remove him from the ability to claim his Fifth Amendment protection against self-incrimination, thus forcing him to sit for a deposition under oath. So Castor's side of it, which will be challenged, I'm sure, by the prosecution, is to say, I was trying to do her a favor. I couldn't meet the criminal burden. I tried to set the table for her to get paid in the civil case. Your reaction?
Well, Michael, I think this plays very nicely into what Cosby's attorneys have been saying over the last couple of weeks, which is that the current DA is using Cosby's case to fulfill a political promise that he made, not to pursue justice, not to follow where the evidence takes him, but really to just say to the Commonwealth, look, I promised you when I was running for DA that I would prosecute Bill Cosby no matter what, and now I'm doing what I promised you. This is very troubling to me as a citizen, and anyone should be very troubled by the fact that a district attorney can use his powers, the government power that he possesses, to make a promise, and then a subsequent district attorney can try to undermine that promise simply to fulfill his own political ambition. So I think this is a troubling matter. I hope the case is dismissed because this, I think, undermines everything we believe in this country about the ability to trust what our government officials tell us and what they do.
Ariva, it occurs to me that the emotional fate of 50 different women is now resting on this one case because it's the only case where he faces criminal charges.
And it's a sad thing because this is a prime example of such incompetence. I cannot believe that the current district attorney didn't have this information available to him before he filed these charges, yet he wants the entire public, he wants this case to rest on this deposition testimony when we now know that the former district attorney made a very specific promise not to ever use this testimony in a court of law. So I don't see how he can move forward with any kind of integrity to prosecute Bill Cosby on the basis of this deposition.
Mark O'Mara, I don't want to convey to people at home that this will be uncontested. I anticipate, and I have a statement that I'll get to in a moment, that it will absolutely be contested by the current DA who will say, we don't believe there was an agreement, or to the extent there was, it wasn't binding, or he'll say that even the former DA left open the door that he would bring charges at a later date. Mark O'Mara.
Which he did. Let's back up a little bit. An immunity agreement is a tool used by a prosecutor, and I as a prosecutor can say, I won't use this information against you. But the idea that they promise forevermore never to prosecute Cosby would be way outside the norm of an immunity agreement and inappropriate. What they can't do is use that precise statement against him in their case in chief, meaning if there's other information out there, and I'll give you an example, we now have similar, what we call, Michael, you know, similar fact evidence. We have a number of other victims out there that he could bring in and say, the facts of that case are so similar to the facts of this case that this jury should hear about it. That similar fact evidence was not available 10 years ago and is very significant evidence. So that's the first thing. Second thing, if Cosby were to get on the stand and say something in derogation or opposition to what he said in the deposition, it can still be used. If I go in and say the light was red in my deposition, I go to trial and say the light was green, even with an immunity agreement for what we call impeachment, they could then use my deposition statement. So there's a lot of nuances here that are not going to be vetted out by one
Understood.
But Michael,
decision. Can I make one other observation to Bill Brennan? Bill, you know, we're both lawyers in the Philadelphia area, and you know that there's been a lot of head scratching among attorneys who say, why the heck did Cosby speak so openly in his civil deposition, especially when he had such a skilled attorney at his side? Wouldn't this email explain it? I mean, it all kind of fits, doesn't it? That Cosby spoke so freely because he was testifying without any fear that he might get charged for that which he was about to say.
Absolutely. At the time that the agreement was reached, Bruce Castor was the elected district attorney of Montgomery County, Pennsylvania. In that capacity, he had the absolute authority to bind the Commonwealth, not just during his administration, but through his successor's administrations, to this agreement. And the problem is, it's fundamentally unfair to renege on the agreement. Mr. Cosby gave up one of the most valuable rights we possess, the right against self-incrimination, based upon the promise of the district attorney at the time, Mr. Castor, that he would not be prosecuted. Now, it becomes hot fodder during a election campaign here in Montgomery County in the fall of 2015, and the first assistant district attorney, who's now the DA, runs basically on this issue. Similar to the '88 Bush-Dukakis campaign, when the pardon of Willie Horton was bannered about.
Political issue. Hey,
All right. So now, I am going to want you to be looking through the materials that I have given you, because remember, this is going to be our transaction material, so to speak, that we have so far. And so we need to be going through that in an effort to understand the client's goals. And at some point throughout, we're going to talk about that thing that we talked about earlier, that best case scenario and that worst case scenario. We're going to look at some more facts from this scenario, but we have a lot of facts here in our materials. I'm giving this to you because I have identified that we struggle in the area of being able to take a large amount of information and isolate relevant facts. Okay, and so right now, is there anything that we can see here just from the facts that we have so far that would be our definite worst case scenario? We're given the opportunity now here to look back on the pitfalls and the problems that it seemed like probably were not crystallized at the time that this was going on. But as a bottom line, a worst case scenario, our deal breaker bottom line would be what if we're representing Bill Cosby in the negotiations with Andrea Constand? Yes.
It is deemed admissible for the criminal case.
Okay, so that is deemed admissible. Okay, that's great, but I want to go even further. I want my drop dead bottom line. It's in that area.
Yes.
Okay.
It goes to Cameron, is that
I want what my bottom line would be in these negotiations, in the civil case. Because we're in the civil case now. Okay, so we understand where we are. Do we understand that we have the criminal case is going forward at this point, the investigation, and then at some point the DA realizes that he does not have sufficient evidence to bring a criminal case beyond a reasonable doubt. And so then there's created this scenario where he is, the DA, is going to agree not to bring criminal charges against Bill Cosby. But then Andrea Constand then sues him in civil court. And so what in that civil negotiation, and we are navigating that with the client, what is going to be our drop dead bottom line going in? Based on what we've learned now. Yes, ma'am. Not to do what for Bill Cosby? Yeah, not to be criminally prosecuted by doing what? By not doing what? By not doing what in the civil case, which is causing a problem. Not testifying. I need to go in Bill Cosby saying, okay, if there needs to be some utterance of these events, we need to create a situation where we can get out of this thing without him ever saying a word. That didn't seem to be crystallized by the parties. If you look through your facts, you'll see there not a one-day deposition, not a two-day deposition. He sat down 2, 3, 4 days of deposition testimony in that civil case. So that is the place where I'm saying to myself, I may need to come back and restate that position at some point. I'm thinking I never would. But I need to go with my bottom line. That's my bottom line. Because that's, right now, Bill Cosby is thinking about his image. You know, he's America's dad, you know, the Huxtables and all of that. But really and truly, his real problem is not money. His real problem is being locked up behind bars. He does not see that back then, but we have to be able to foresee that calamity. Yes, ma'am.
So is that bottom line to not testify, meaning not testify against himself if a criminal prosecution?
Not testify. See, because now we're in the civil case. See, so they're going to have depositions. Andrea Constand is going to have a deposition. Bill Cosby may have a deposition. We need to try to head that off. Okay? At some point, I'm going to be working my way through what all of my bottom lines are. My bottom line before that is I really don't want her to testify either. But I could probably, you know. But, so we want to try to settle this case. I'm assuming there is some amount of money. You know, in your packet of materials, I have given you what the case ended up settling for. We don't know what the scenario was, whether that money came out of his pocket, whether he has some type of insurance, or somebody who's going to set give the amount of authority. If he's, you know, self-insured, he's taking care of that himself, I'm sure, that he probably did in that particular case. He may have his top line amount of money at $5 million. And so these are the kind of points that need to be established throughout that negotiation. And then you have to understand what her interest may be. So let's deal with a few more facts of cleaning up some of the factual background of the situation. I had the opportunity to talk about this in another context a couple of years ago when this was all going on.
Now, Joey, let me ask you this. Let me just start here. Can we also add in the part that Cosby also thought the deposition was going to be sealed? Can you tell us about the piece that went on with the deposition and all of that?
Yes, that's a very good question that your professor raises, and here's why it's a great question. Because there are two layers. Number one, Cosby figured that nothing ever that he said in that deposition would ever be used against him. That's why he gave it, right? He would not have talked. And then the second piece was he was comfortable in speaking not only because he knew it would not be used against him, but because he knew the press would never get a hold of what he said because everything he said was sealed. That is, it was locked in a box and not able to come out for the press, not able to come out for attorneys, not able to come out for prosecutors, not able to come out for any purpose. When something is sealed, it's locked in a box, and only upon an unsealing order is it now unlocked and everyone gets to see what it says. So now we fast forward, and lo and behold, the deposition becomes unsealed. There was a motion to unseal the deposition. Cosby's lawyer said, how are you going to unseal it? This is something that's locked in a box and you're not permitted to unseal it. The judge said, well, I'm going to unseal it because you have become a public moralist.
I have another question. Yes, sir.
So, I would imagine that I think this probably wouldn't have an unintended backlash because if the previous DA makes a deal and this new DA is saying, well, that doesn't matter as previous DA, doesn't that basically undermine the entire authority that the DA has? If his promises can't be upheld if he's no longer there?
Can you hear that?
That's a wonderful question. Let me say this. Your class is brilliant. Let me say this. What the now DA is saying is that you did not, former DA, bind the Commonwealth of Pennsylvania. And the reason you did not bind the Commonwealth of Pennsylvania is because you did not get it in writing. And he's saying two things. The new DA, to be clear, is saying two things. Number one, I'm not undermining your authority because you didn't get it in writing, and in order for an immunity agreement to be effective, it needs to be in writing. And number two, the new DA is saying a district attorney can't offer immunity, only a court can offer immunity, and since a judge never offered immunity, there was never any immunity, and so therefore I'm proceeding with the prosecution. And so I'm not undermining your authority because you had no authority to bind the Commonwealth, and you had nothing in writing which does bind the Commonwealth, and so therefore that's what the new DA is relying upon to do what he's doing, which is to prosecute Cosby on the strength of Cosby's own testimony in a deposition.
Okay. Yes, sir. I got a follow-up.
One thing I would imagine at least is, at least during the interaction between the original DA and Bill Cosby, all those interactions and deals made for him under the good faith of the authority of the DA. So wouldn't that kind of have, I mean, isn't there some kind of umbrella of good faith between when you're talking to someone with authority like a DA and he tells you something, so you're in good faith recognizing and believing that he has the authority to do it?
Well, give us a ranking on that.
Exactly. Listen, that is a very astute observation, and I'm going to tell you how astute it is. There's a doctrine of law called detrimental reliance. And what that means is when you rely in good faith upon something someone told you, right? If you rely upon it to your detriment, meaning you're hurt by it, now it cannot be used against you because that's the exact argument here. Cosby's saying, I relied in good faith upon the former DA telling me, whether it was in writing or not, whether he had the authority or not. I don't know. I just know he said, give a deposition. Anything you say will never be used. Go ahead, have at it. And now, and I rely upon you in good faith, now you come back to bury me with what you told me would never bury me. And so the law calls that detrimental reliance. And whenever you rely in good faith upon a representation made by someone in authority, and that representation that's made to you in good faith comes back to harm you, you can say, since I relied upon it, it cannot be used. And that's one of the arguments that Cosby's making, and that's one of the arguments that an appellate court may very well use to rule that Cosby's deposition cannot be used against him.
Now, I haven't even gotten to my questions yet because I want to try to, because there's so many wrinkles in this case. Now, what about the piece where, you know how when a party is usually represented by their attorney, and these representations were made to an attorney that Cosby had that is no longer with us.
Right.
Talk about that, please.
Well, the fact is unfortunately, Cosby's lawyer at the time, who was engaged in these discussions, is dead. But who's very much alive is the former district attorney. And the former district attorney, Bruce Castor, went to court and he testified in a hearing and he said, hey, I told Cosby I would never use this against him. I issued a press release saying we're going to dismiss the case. And as a matter of fact, what I did was, because I wanted Andrea Constand to have some measure of justice, Now, understand that our system is imperfect. What it does to pay or compensate victims of many things, injuries, sexual abuse, you name it, is to give them money. Now, money is insufficient when your dignity is taken away, but that's what our system has to deal with you. So, what the prior DA, Bruce Castor, said was, since we won't prosecute her criminally, maybe she can get a measure of relief in civil court and go after him for money, right? He wasn't opining as to whether that was satisfactory or would ultimately deal with the underlying abuses or the humiliation or what have you. He just said, I can't prove it criminally. I, however, am going to make this agreement with Cosby so that you can go and get your money from him in the event he's held to have done something wrong. And the only way you can get money from him is if he participates in the process. So I'm going to allow him to participate by saying, say everything, tell her everything, when, where, how, who, what, and I'm never going to use it against him. And ultimately, that's exactly what Castor did. Allow Andrea Constand to sue him civilly by allowing Cosby to give a deposition and to talk, and thereby forfeit his Fifth Amendment right against self-incrimination. And that's what happened.
Okay, now, before I get that to you, Joey, I want to clear up this piece about the deposition transcript. Was there not a FOIA motion to release some court documents that had excerpts from the deposition that had been unsealed, or has the entire deposition, I'm talking about a certified copy of that deposition that would hold up in a criminal trial, has that been ordered released?
My understanding is there were portions of the vast majority of that deposition is out. There were portions of the deposition that have been made public, and those portions are so damning and damaging as to constitute the deposition itself. Meaning on the critical issues, in depositions, there are a lot of things that your class should be aware of that are asked of you. Where do you work? How long have you worked there? What do you do? How long have you done it? How many children do you have? Where do they go to school? What are their names? Those are issues that relate to who you are, but they're not critical issues relating to the liability of what you're doing. And in this particular case, critical issues relating to the liability of Cosby vis-a-vis his relationship with Andrea Constand, when he met her, how he met her, what he did with her, what if any pills he gave her, how many pills he gave her, what he did to her when he gave her those pills, all that is out. So while there may be portions of the deposition that we haven't seen, I would argue that those issues relate to issues that we're not really concerned about. What we are concerned about is very much public, and that's at the core of what prosecutors want to use against Cosby to prosecute.
Okay, now hold on, Joey. Prosecutor. I'm going to let you be the prosecutor, and I'm going to be the defense lawyer. I'm going to say to you, that's all well and fine, Mr. Prosecutor. However, that's hearsay until you can get a proved up copy of that transcript. Tell me where I'm wrong in that case.
Well, here's the problem. The problem is that an admission by a defendant operates as the exception to the hearsay rule. And so to the extent that a person makes an admission against themselves, that's plainly admissible in court. And any admission that a defendant gives, for example, a defendant in a case tells their friend, I was with Andrea Constand. Tell somebody else, I did X, Y, and Z to Andrea Constand. Tell somebody else, I gave Andrea Constand pills. Tell somebody else, I was abusing her. All of that is an out-of-court statement. Yes, it is. However, to the extent that it's an admission, it comes in as an exception to hearsay. So technically, while you might suggest that it's an out-of-court statement used to prove the truth of the matter asserted, since it's an admission being made by the defendant, the court is going to accept that as reliable and therefore admit it into evidence.
But Joey, it's not proved up. It's just something that's out there on TMZ now. It's not the actual one that the court reporter, that they go over to Veritex and get a certified copy of that document. To me, until you have that, because the person themselves, the declarant, is not going to testify, that document is hearsay.
I understand what you're saying, and it's a very good point you make. I think the retort to that point is that it becomes, number one, look, you're right, to the extent that if there's a certified copy that you swore to under oath, that's the best evidence. And if you don't have that, I can wiggle out of it and say, hey, I never said that. But if you have a TMZ or some other type of undocumented, unsworn statement, and in court they use it against Cosby, it becomes a credibility question. Because he'll be confronted with it. And they'll say, hey, Cosby, didn't you tell TMZ that you knew Andrea Constand, that you were with Andrea Constand? Didn't you tell the New York Times, A, B, and C? If he admits or denies it, it's going to be up to the jury to assess his credibility as to whether he's lying or being truthful. So yes, a certified copy of any document sworn to under oath is the best evidence. And if you don't have that, it's troubling. But you still could be confronted with some other type of thing that you said, and if you deny it, it becomes up to the jury to say you're either being credible or you're lying.
Okay. So you think it comes in even if it's not a proved up copy of that transcript?
I think if he testifies...
He's not going to testify now.
If he doesn't testify...
He's not going to testify. You think he's going to testify?
I think he's got to explain. Here's my issue.
This deposition debacle, trust me when I tell you, if Bill Cosby is my client, he will never utter another word in the wake of days.
It's a very good point, and it'll be up to his attorneys. But look, he's saying an awful lot by not testifying because of the deposition, and they may be things that he may have to explain.
Now, Joey, let me ask you this.
Okay, so I just wanted to get through that part so y'all can know the fight, and you gotta have the fire in your belly to go keep going with the fight for it. Those are what, to me, were a lot of prosecutor answers, but for me, with me being on the defense side of things most of the time, no thank you for me. And you're going to see we're going to work through this a little bit more. I'm going to move and come back to some of these facts, but what I do want to let you know is that in that civil case, okay, keep in mind you have your facts, and that we're gonna take some time and look at them and kind of see if we can isolate some information from those written facts. But in that civil case, in state and federal courts, the judges want you to try to resolve those issues. That is just like the standard thing that you are going to see coming out of the gate whenever there is any case that's going to be filed. The first documents that are going to be coming from the court are going to be documents that are letting the parties know that they need to find a way to do some alternative dispute resolution before we get to this costly enterprise of litigation, which is going to at some point require maybe a jury to come in. That is very costly, all of the resources that have to be put in place to try a case. And you remember when we had that Stormy Daniels case that we looked at, I showed you that particular docket sheet, and you will see on there one of the first things that is going to be filed by the court is an order, right here, number 10. It's the notice to parties of court-directed ADR program. And so the parties have to follow the court's orders where that particular order is related. And so it's letting the parties know early on that per local rule of the particular court that you need to try to find a way to settle your dispute before we get down the road. And in addition to that, the court is going to want you to let them know whether we're going to have a private mediation, or if you want Your Honor to appoint a mediator. Either way, the court wants some good faith effort for the parties to work out their dispute. Now, some people will work it out even before they get to actually having to go to a mediation in that particular case. But the court is saying, hey, when you come to the first conference that we're going to have in the case, I want you to be ready to tell me which one of these avenues you're going to go for. So they are really wanting the parties to work out their disputes in some type of a mediated settlement, or even some type of an informal settlement between the parties before they get to that point in the particular litigation. Now, we are going to look at our plan that is based on this getting to yes type of project, which has a 4-step approach that we're going to work with this evening with we have our little plan paperwork there, and because you can't just go into the mediation, just like, okay, I'm just going to show up to mediation. You have to have a plan. First of all, like we talked earlier, you got to know what your bottom line is, and I'm trying to wiggle out of this thing early on without Bill Cosby ever uttering one word, because you can see now all of the reasons why I would want that to be my bottom line. And so what you have to do is you have to separate the people from the problem. Where we talk about the emotions that are going to be baked into a very highly emotional situation like this. Okay, you do that by focusing on the interest. Each party is going to have some type of interest. Okay, so now what are Bill Cosby's interests, you just think, just off the top of our head? Yes, ma'am.
Not having his testimony brought in, his deposition brought in.
Okay. Okay. Yes, that's gonna be a baseline interest. What are some other just casual interests? Mr. DePolo, did you? No?
I was going to say going to jail, but
that's definitely going to be an interest.
Okay.
Okay. Yes, ma'am.
And maybe as little as possible in installments.
Yeah, but that's going to be on the far end because he has loads of cash. Okay, he got the money to bankroll this. Okay, I'm telling you, I think he probably has authority of about $5 million. I'm thinking he has more money than that. Okay, but I'm thinking he set a budget on this of at least $5 million. Okay, yes, ma'am.
I think just handling the situation like as much discretion and confidentiality.
Why? What's the interest? Why?
So that that information isn't leaked to the public.
Why?
His reputation.
Yes. Yes. Or what about Miss Constand's interests? You have to be focused on what her interests are, because then you have to be able to leverage that. Okay? All right. So what do we think there could be for Miss Constand? Yes.
Money.
Okay. Money, definitely. Okay. Yes, ma'am.
Justice for yeah.
Okay, I don't want to be so cynical. I'm a defensive. I shouldn't be so cynical. Hey.
Accountability.
Accountability. The Monte. I'm sorry. Oh, let me go crawl under my bed. Okay. Yes. Justice, great. Okay. But Justice has, I feel like that's going to be down there with her where, what was that, where money is for him? Justice.
Wouldn't she want him to be accountable for the things that he did to her?
Yes, but see, it has already gotten past her because the guy has already said, I'm not going to bring charges against him. So her justice now, she could probably get that justice through the civil court, but the end road of that is going to be money. So, but in the process, what would be some other interest she might have? Yes.
I don't know if this is it, but
Okay, fame. She is not as famous as he is on his Twitter account. He probably has more followers than her. But what would be a step down concern or interest?
Opportunity? I mean,
Okay,
I'm
what
just saying-
kind of opportunity? What kind? I like that.
Write a book. I don't know.
Okay. I'm gonna come back to that because I'm gonna be looking for something like that. What about another interest? We're not talking about fame, but what? Yes.
I mean, she might just want this to be brought to light, like have media.
She would want it to be brought to light, or
Yeah.
okay, or what could be another? Okay.
It could be that she wants it all confidential.
It could be that you see, let's think about this now. See, I really don't know what the facts are that eventually you will see in your materials. So she met Bill Cosby through her job at Temple University as she was a high-end person over there with the women's basketball program. So, eventually all of us want to, make money in life. We want to have a career or whatever. So, I don't know. If she wants to go and work at other schools, because she met Bill Cosby because of his position on the board of trustees there. Okay, so I don't know. She may have an interest that she might not want all of the facts to get out about it. I mean, much of it was very much, known at that point. But a lot comes out when you take depositions, when you start to get testimony under oath. So you just never know that it could be that, there's some interest she may have there. What about what happens when you are dealing with a high-profile individual on the one side? What happens to your life?
You have no privacy.
And then who else?
Like they're gonna look into all your relationships. And
Maybe. And who else?
family.
Your family. She may have some interest in keeping her family protected from having their lives just brought into full chaos. These are the kind of things you have to be thinking about. You have to put this down. You got to plan this all out so that when you go in there, you have some things to use in your negotiation, because I'm trying to get the gold standard for my client, which is for him to never say a word. Okay? And so there may be some issues, like you said, maybe somebody has an underlying thought of their mind, I want him to do justice or whatever the case may be. If that's the case, I need to push on that and find a way to develop the relationships that need to be developed to get what I am trying to get, so that other party can get what they want to get. Okay? And so what I really want you to do is to be mindful of all of this when you start to look at your bargaining plan that we are going to work on. We want to be mindful of our best case scenario, our worst case scenario, and understanding and developing the opponent's interest in that kind of. And then once you gather all that information, then you want to come back and reevaluate your bargaining positions. And so what I want you to do is to, I'm going to ask you. So remember I told you that there are some times where, you know, we may have clients that we don't really like, or so I'm going to ask you all, which one of these two do you want to represent? If you want to represent Bill Cosby, I want you to check A, and if you're going to represent Ms. Constand, I want you to choose B. I want to get a temperature just to see, and I know that you're not going to tell me outright, because the last time I learned from that. So, okay, so Bill Cosby A, Ms. Constand B. So we all want to represent America's dad? Used to be? Wait, okay. Well, we have somebody who's saying no. Okay. No, thank you.
Bill Cosby A.
Bill Cosby A, Ms. Constand B.
Okay.
She just outed herself. Okay. Well, this is okay. Okay, y'all, come on now. Okay, so this is the thing. So I'm just letting you know right now that, you know, you have to give the same amount of chutzpah to the clients that we don't necessarily want to represent as to the ones that we do now. So because, you know, you're going to be working at that big fancy law firm, and one day this Bill Cosby comes into the law firm, and then the partner is going to say, oh, Miss Cooper, let me tell you what I have. I have a nice, tasty little morsel of a case for you today. And you have to be ready to say, woo, okay, I'm ready. I'm ready to represent.
That's how I sound.
No, you be like, nah. You know how you be like, nah. The first thing you do is you put on the face, you be like. And I have to tell you, you know, that you can't let me see it on your face. You gotta be like, ah. Okay. So what I want you to do is, but I'm gonna ask my question to you. I'm gonna clear this room out. I want to ask my question. Now, when you see this question, I just want you just to go with it. Just go with it. Okay, don't judge it. All right. This is all one sentence. These are the things I want you to keep in mind while you're thinking about the question. So, do you think an excerpt from the deposition transcript of Bill Cosby's testimony, okay, I'm just saying, parenthetically, given to facilitate a civil settlement only after the district attorney agreed not to bring charges and to grant immunity from anything said, which was thereafter sealed in a civil case as a result of a settlement and confidentiality agreement Cosby entered into with Constand. The same Constand who is the subject of the criminal case who agreed not to initiate a criminal complaint should have been allowed to be used during the criminal trial and considered during jury deliberations when during the criminal trial, Bill Cosby invoked his Fifth Amendment right against testifying in that particular case. If you believe that deposition excerpt should have been used, notwithstanding the fact that you all are taking evidence right now, I don't want to influence your decision. Choose A for yes, or choose B for no. A for yes, if you think the deposition excerpt should have been used, or B for no.
I think it's still like this is waiting.
Oh, okay. Yeah. Thank God. Even though you all don't like him and don't want to represent him, you still think that justice has a place in life? I don't know. But let's just see as we work through there any questions so far where we are on this problem? Really? Everybody has it? No questions. Okay, so you understand that we have kind of like a twofold issue that we're trying to work through with the Mr. Castor's side of the agreement. Who knows what part he's going to play in it, because actually we're in a settlement with Andrea Constand. So there are multiple pieces here that we are trying to put together. Okay, so for Mr. Castor, what is it that we're trying to get Andrea Constand to facilitate from Mr. Castor's standpoint? Yes.
Well, he wants to allow her to have a civil case and be able to depose Cosby in that case, because if there was any chance that Cosby would have thought he was going to face criminal liability, he would have just pled the fifth.
Okay, so there are two things there, though. So what's the first thing?
That she can bring a civil case.
Regarding Cosby, what are those two things that he's needing from Mr. Castor?
He needs an agreement that he will not be prosecuted criminally.
Okay, and
From Castor?
uh-huh.
Well, it's in exchange for him.
Okay, that other thing that they were talking about, that I-word, immunity. That's the piece on the testifying.
Mhm.
The one part is, as a DA, he has the duty and the authority not to bring criminal charges. But also, there was a part that I think kind of got lost. I think it kind of got pulled all to one ball of wax there, because the parties didn't seem like you had the left hand not necessarily knowing about the right hand to know that there are two pieces here that need to be crystallized, because I want the top of the line deal if I am Bill Cosby. There are some parts where there were ideas and the facts that you see in your written materials where, and we'll talk about the ethics of all of this, but it's clear that people were ready, willing, and able to agree to these things. And so where the immunity is concerned, it seemed like, it sounded to me that there would need to be some type of a court order. So somehow I need to make sure that, some people, one guy was saying that he didn't think that Bill Cosby wanted, the problem now is that his attorneys from that time are deceased, are no longer with us in other capacities or whatever the case may be. So it's hard to know, and that is the reason that we need to get things in writing. And so on the one hand, I need to try to see if I can get, you will see that there was some third party, that we will have third parties if you look on the page 2 of your plan, where you might be able to bring in some third party support, whatever the case may be. If I'm letting him think I might testify, I also need to try to make sure that I have that order from the judge saying that there is that immunity. So those things have to, and so that has to all be worked out. You got to try to understand, how am I going to get this done? On the one hand, you can see he's a prosecutor, so he may have more affinity for the plaintiff, and so you got to try to see how you can get that part of all of this done. At the same time, you got a high-profile individual here. The DA probably didn't want to put pen to paper on this kind of stuff. So these are all the kinds of interests that we need to be thinking about before we sit down to actually go into the room with the other side to do the negotiation. Okay, so now let me just bring in just where, so I'm going to bring you all up to date. Okay.
6 days of deliberation.
This is your first trial.
Back telling the judge that they are hopelessly deadlocked.
Cosby on trial for 3 counts of felony aggravated indecent assault for allegedly drugging and then sexually assaulting Andrea Constand back in 2004. ABC News correspondent Lindsay Davis is at the courthouse in Norristown, Pennsylvania. Lindsay, what have you learned about the decision? And I guess the big question at this point is, since we know it's a mistrial, will the prosecution retry this case?
Yeah, it's still too early to know at this point. Prior to getting to this place, the prosecution's office had said that they were not going to make that decision immediately. So I think that because we've been in these deliberations now for more than 50 hours, slowly the prosecutor's office was able to see that this deadlock situation was the likely outcome, and they did decide days ago that they were not going to make an immediate call about it. And Lindsay, why do you think the jury wasn't able to come to a conclusion one way or the other? Well, I think that you have to harken back to 2005 when Bruce Castor, the then district attorney, decided that he wasn't going to press charges, that he wasn't going to prosecute Bill Cosby because he said at the time that he felt that Andrea Constand had ruined her own credibility, that she would not be believed by a jury. And I think this is a bit of an I told you so day for him, in part at least, because in the end it seems that the jury wasn't 100% able to trust her account.
Lindsay, thank you. Let's bring in ABC News legal analyst Dan Abrams. Dan, who joins us on the phone now. Dan, what do you make of this outcome?
Well, this was a tough case from the beginning, and I think a lot of people feared that there could be a hung jury here. Because remember, even if these jurors believed that it might have happened, or probably happened, just as Andrea Constand laid it out, that's not enough for proof beyond a reasonable doubt. And as Lindsay just talked about, this has always been viewed as a tricky case. But look, you got to give these jurors credit. The fact that they tried for this long to reach a verdict is unusual, meaning very often at Friday morning, jurors don't have a sense of that they're going to have a verdict. By Friday afternoon, you usually let them go. These jurors kept going and going and going and trying to reach a verdict, simply unable to do so.
We know the jury consisted of 7 men and 5 women. Dan Abrams, we really appreciate your analysis on this breaking news as we look at Bill Cosby at the courthouse there in Norristown,
details about Bill Cosby's sex assault mistrial. A juror speaking only to ABC, taking us inside those 52 hours of deliberation. This is a stunning account, and revealing why the 12 jurors were ultimately unable to come to an agreement. ABC's Lindsay Davis has the story.
From crying outbursts to intense arguments to a possible hand injury after one juror punched a wall, the 52 hours of deliberations inside a tiny room not large enough to even pace took a toll on the jurors in Bill Cosby's sexual assault trial, according to a juror in an exclusive interview with ABC News who describes the experience as grueling and emotional. The juror, who agreed to speak to us on the condition of anonymity, said 2 jurors prevented a guilty verdict. 10 of the 12 jurors agreed Cosby was guilty of 2 of the 3 counts against him, having a sexual encounter with accuser Andrea Constand without her consent, and giving Constand drugs without her knowledge to prevent her from resisting. But the juror also told us they were near acquittal on 1 count, that Constand was unconscious during the event. The vote, 11-1. When they first entered the room and took a non-binding preliminary poll, the jurors overwhelmingly said they thought Cosby was not guilty on all 3 counts of aggravated indecent assault. The juror says the holdouts against finding the 79-year-old entertainer guilty were not moving no matter what. Constand says Cosby drugged and sexually assaulted her at his home in 2004. He says the encounter was consensual. Although only 1 other accuser was allowed to testify at trial, more than 50 other women have come forward with similar accusations. Cosby has also denied those allegations. ABC News reached out to several other jurors who declined to comment. But the juror we spoke to tells us despite the fiery exchanges and intense pressure, the group of 7 men and 5 women are now friendly and keeping in touch by phone and text. Lindsay Davis, ABC News, New York.
This is really fascinating. Let's bring in ABC's chief legal analyst, Dan Abrams. Dan, always great to have you on this. But this notion that the jurors would enter that room, a non-binding vote, all of them saying not guilty, and then over the course of 6 days, 10 out of the 12 to decide guilty on 2 counts.
Yeah, look, it's very typical for jurors to take a straw vote when they come in and say, yeah, where does everyone stand? And everyone sort of raises their hands. That's part of the deliberation process, right? That's not a binding verdict. That's not a ruling. That doesn't happen until the verdict form goes in. But what's astonishing here is that you had all of them saying not guilty, and then as the deliberation process went on, 10 to 2, and this is out of a movie. Right? This is like, 12 angry men the other way. It's I've never heard of something like this, where 10 of the 12 jurors apparently changed their minds to the point from where they were ready to acquit, prepared to convict by the end.
Lindsay was reporting there was a tiny room, not even room to pace, this juror apparently said, but fists into walls. I mean, this could come up again.
Well, I think that you can expect the defense to file a motion and say, look, they were ready to acquit if the room hadn't been so terrible and the situation hadn't been so bad. Bill Cosby would have been acquitted, and therefore there should be no retrial. They're not going to win on that motion. They'll likely make it, but it's not the sort of motion you win on. To win on something like that, you have to really show juror misconduct. And even when you show juror misconduct, typically what you get is a new trial. And Bill Cosby's getting a new trial anyway. So, really interesting, though, this reporting on this.
A peek inside that juror room. All right, Danny Room, always great to have you.
We're going to move on now to our exclusive interview with one of the jurors who convicted Bill Cosby. 22-year-old Harrison Snyder sat down with Lindsay Davis, and Lindsay, he is convinced he made the right decision.
That's right, no second guessing. Good morning to you, George. Harrison Snyder was the youngest of all the deliberating jurors, and at 22 years old, he wasn't even alive during the height of Cosby's fame. He also admits he wasn't very aware of the Me Too movement. And while many have said that this case came down to he said, she said, Snyder says for him, it came down to what Cosby said himself.
This morning, a stunning revelation that it may have been Bill.
This is the second trial now where he's now been found guilty, where they have now, changed some things, where they let some prior witnesses come in, prior bad acts, that's what they're called, prior bad act witnesses, and they also allowed the transcript, the excerpt to come in. So now this is one juror talking about that.
Cosby's own words that sealed his fate.
What was the evidence that made you sure, beyond a reasonable doubt, that he was guilty?
I think it was his deposition, really. Ms. Cosby admitted to giving these quaaludes to women, young women, in order to have sex with them.
For weeks, there was speculation about the outcome. But this morning, we hear just what was going on inside the deliberation room during Bill Cosby's retrial, thanks to juror number 1, Harrison Snyder.
But when you entered the room for the first time, were you sure that he was guilty?
No.
So what then made the difference for you once you started deliberating?
Hearing everyone's comments about certain pieces of evidence and going through the different counts.
So you don't feel, even now, that it was an open and shut case?
No.
The 22-year-old says prior to the trial, he didn't know much about Cosby and knew nothing about the allegations against him.
I really didn't know a lot. I knew he was an actor. I knew that he did The Cosby Show. I never watched The Cosby Show or anything. I'm a little too young for that.
What did you know about the allegations prior to becoming a juror in the case?
I didn't know anything. I don't watch the news ever. So I didn't even know what he was on trial for.
At Cosby's first trial last spring, the jury deliberated for more than 52 hours, but was unable to come to a unanimous decision on whether or not Cosby drugged and sexually assaulted former Temple University employee Andrea Constand at his Pennsylvania home in 2004.
When Andrea was on the stand, did you believe her?
Yes.
What about those other 5 women who testified?
Yeah.
If you hadn't heard from the other 5 and you just had her word, would that have mattered to you?
I don't think so, because in the deposition he stated that he gave these drugs to other women. I don't think it really necessarily mattered that these other 5 women were here, because he said it himself that he used these drugs for other women.
So you found it to be his words that were the most damning of all?
Yeah.
That's why we said Me Too!
While many in the court of public opinion felt the Me Too movement loomed large, perhaps even helping to sway the jury.
Are you well aware of the Me Too movement? Did that have any factor, would you say, in your decision?
No. I really only found out about it after I got home, and then I looked online to see what everything was. I didn't really even know about the Me Too movement.
Snyder describes the jury as being all on the same page when it came to arriving at that unanimous guilty verdict on all 3 counts.
Some have said that I made the right decision, and then some people have said that they still think that he's innocent. And I just tell them, if you were there, you would say the same thing. You would say that he's guilty.
Sitting here today, is there any doubt in your mind that you guys came to the right conclusion?
No, I have no doubt at all.
As for inconsistencies in Constand's story, Snyder says that they were explained away by the prosecution's very first witness, a sexual assault expert, who testified in the reporting delays, inconsistencies in statements, and continuing to keep in contact with the perpetrator are all normal behavior for a victim of sexual assault. But Georgie says there was no dissension, no tension at all in that deliberation room. Their verdict was clear.
Pretty clear. Okay, Lindsay, thanks very much. Let's talk about it now with our chief legal analyst, Dan Abrams. Not much comfort Cosby team can take from this.
No, I mean, look, defense attorneys like to try and cite what jurors say after the fact, usually ineffectively, in an appeal, but this provides no fodder for the defense at all, because he's saying it wasn't the 5 other women, which would be the most controversial issue that was in this case versus the first case, that swayed his decision. What I found so interesting is it's a reminder that expert testimony does matter. Right? We always like to say, oh, these experts, anyone can buy an expert, both sides. This guy's making it clear that the expert who testified about what it means to be a victim mattered to him.
That plus Cosby's words.
Plus Cosby's words, but at least it provided context for him where when the question was, well, why didn't she report it quickly? Why did it take her a year? Why did she keep calling him after the fact? These are all questions that came up in the wake of the first trial. And this guy's saying the sexual assault expert put it into context for us, first witness.
And it's so clearly a case of first impression for this juror. Is there anything now that Cosby's team can look to try to get to win on appeal?
Yeah, the biggest issue, and it's not a frivolous argument, is that the 5 additional women who testified in this case about what they say Cosby did to them shouldn't have been allowed to testify. The argument is this is what is called pattern and practice, meaning this was his MO. He did this all the time. That's why the judge allowed it in. Doesn't mean that it's still not a controversial decision. That will be the central appeal.
Dan Abrams, thanks very much.
I was reading some things over the weekend that he being Bill Cosby, may not face jail time. That if you look at the judge letting him out because people thought his bail would be revoked, and it wasn't.
Yeah, I don't quite buy that. I mean, I wasn't surprised that he was released, and I would be very surprised if he didn't serve any time in the context of this case.
We'll see what happens.
Yeah.
So these will be additional facts that are in the packet of materials that we have. But now, so the things that they're talking about there are, so I don't know if we ever really got the date that this thing happened. She was never able to remember the exact date that it happened. She went back, I mean, these were visits where she went to his house for dinner on numerous occasions. And when this event happened, there were prior events where she had gone there and he tried to make a move on her. And so then she goes back. Then, after this event, she went back to his house for dinner on 1 or 2 other occasions and went with him on an overnight stay to a casino in Connecticut. So that is the thing that they were talking about the expert who explained away these things that happened. But these are facts that play into the, not only are there facts that would play into the criminal conviction, but these are going to be facts. These are data points that would, that a negotiator has to find the right way to use, okay? Because when we talk about, at some point in our negotiation, you want to avoid threats. You don't want to be like, well, if this comes to trial, we're going to tell them that you keep coming, blah, blah, blah. You have to be able to strike the right type of a negotiating style when you are negotiating with the other side. These are things that we are going to have to be mindful of now. In transaction 3, at some point, we're going to get to the negotiation stage where we have to use all of the different modes of talking to the other side in negotiations. And so these are things that you have to be able to maneuver when you are working on your plan. So also, so I'm going to go ahead and let you just take a look at some of the written material. Now you have some of the video pieces. This is how this is done. See, not all the time are you going to get like you got in the first transaction. You know, we got all of the different facts kind of laid out for you. You may not think that, but it was laid out for you in a more tightly defined kind of way. Not much for you to have to go through and pull out and synthesize. Then the next problem that we get, there's a much more information that you have to be able to go through and be able to synthesize. In that last project, I kind of let it be up to you on whether or not you were going to do a deal memo. I'm not going to do that this time. I want to see a deal memo for this particular transaction because I want us to get to the point where we can look at the written material and start to synthesize out the relevant information that we need. First of all, the information that you're going to need to be able to, what I hope, to create a deal memo. And then also the information you're going to have to be able to use for your negotiations. And so that is what we're going to do here with this particular project. So I'm going to give you, let's say, until 7:30. Let's look at the materials that we have and work on your worksheet a little bit as well to be able to fill in some of the boxes. What I told you all in that last transaction that we had, how I go through my materials, I mark up things. I'm already looking for things that are going to go in my sections of my agreement. And then later on, I'm going to go back and I'm going to take all of my information and put it in one document that I can use to draft my agreement. And so I want you all to start working on getting to that stage where you can look at information, see what's critical, and then what's not. So we want to, again, look to the interests of the parties. What are the interests besides money? What are the opponent's interests? We want to look at our best case scenario, our worst case scenario. So in the first part, you need to have a problem statement. I must negotiate with Ms. Constand to solve what problem, okay? And it may be multiple problems, but I need to put it all here. I need to get a focus on what is the problem. So we have the luxury here of being able to look back. So what is the critical problem here? Anybody?
His testimony?
Yes. So I need to try to figure out how I can get Ms. said to do what though?
You want her to agree to a settlement without you having to testify.
Okay, so that's going to be one. And how are we going to get there? Because without him having to testify, how is he going to get there? Because his argument is, I'm not going to testify because I will have to invoke my Fifth Amendment right against self-incrimination. So for her, her idea is she's trying to get him to participate in this civil case. So the first thing that Bill Cosby needs to do, if he wants to, let's say, make her think he's going to testify, he needs to do what though? He's not going to testify without what? Right. So that's a problem. That's one problem. What's another problem? When I think about, when I group together my problems that have to do with the criminal side of the house, I talked earlier about the two problems.
Needs to be some form of written record of the agreement or immunity, whether it be a court order.
Okay, so that's going to be the immunity. And what else? What other agreement? Let's work on our criminal side first. Yes.
Agreement not to criminally prosecute.
Not to
Criminally prosecute.
right. I want to go for the whole ball. I want to go for my highest. I want to go for my best case scenario. So when I'm thinking about solving problems, I got to think about all my problems that need to be solved for me to get to where I'm trying to get to. What else is critical here? As far as you talked about it earlier, can you restate it again? I think
That you want to come to an agreement, a settlement agreement, without him testifying.
okay, without him testifying, and what's the point of that? One of is the criminal side we've already dealt with. What else?
Well, he doesn't want to. Testifying could open himself up to additional civil liability. Because, like in this case, he testified that he does to other women.
Okay, additional civil. So what's the basis? Let's just say the basic thing that we are trying to get to is what?
I mean, they want to come to an agreement.
What type of agreement?
Settlement?
Okay, yes. The terms of which would be? Yes! So the one problem is we don't want him to testify, but what is it we really want? We don't want anybody to say anything. Right. And you're saying because of the exposure for the future civil liability, it's not just civil, it's future criminal as well. The fact of the matter is, you will look in your facts, you will see that they did not know at the time about all these other people. Okay. So it would not have been the thought in their minds on the Andrea Constand side about the criminal or civil, because they're not really thinking there are so many other people. What is just a basic reason that the confidentiality would be one? That we talked about earlier. His interest. Yes. He's America's dad. He's Mr. Huxtable. Okay? Yeah. So that's, we got our problems that deal with the criminal case. We want to have some type of confidentiality because of his image. want her to do now? Because she has filed a lawsuit. So what else, what's the other problem you have? We have a pending lawsuit that needs to be dismissed. These are problems. Okay. All right. So this is what I'm kind of working with them in the beginning. These are the problems I want to solve. I'm kind of putting it out there for myself. I don't know how I'm going to get this all worked out because there's so many pieces here, so many people that need to be convinced to do something. I don't know how it's going to work, but I need Constand's promise to cooperate with Castor in obtaining the immunity order and agreement not to prosecute. Because what we need to understand in a criminal proceeding is although the DA represents who? Who does the district attorney represent? The people. He can't go forward without a what? A complaining witness, a victim. Exactly. He just can't say, oh, I'm at home and I think that somebody got raped. Somebody has to come forward and make a complaint. God bless you. Somebody has to come forward and make a complaint. And so there's a whole lot of lip service going on in this case because you can see how they're working behind the scenes with each other. Mr. Castor, he feels bad that he does not have proof beyond a reasonable doubt because her case is so flimsy. Okay, so he feels bad. He wants to kind of help her. Okay. On the civil side, but nobody's really doing anything that's really going to help him. Because she's saying, if you go back and look at the letter that her attorney wrote, they're like, oh, we're going to agree that we're not going to bring a case. She actually agreed not to bring a case. So if you look at her letter now in the future that she has now written to the DA, it's like a wink and a smile. Hey, Miss DA, I got $3 million and you called me. I didn't call you. You called me and asked me for my file where I agreed not to ever bring a case, not to ever be a complaining witness. You called me. I didn't call you. She says that in the beginning. Your office requested. And so that has to be tightened up. You know, I don't know. This is one thing. Everything is on the internet these days, but the only thing that's not on the internet is this confidentiality agreement. I could not find it because, if I had been able to, I would have tried. I looked everywhere. It's nowhere. That's a good job. They hid that. That's confidentiality. That's the only thing that's confidential. I could not find it anywhere. So she says Ms. Constand agreed not to, she says it right there and there, to initiate a criminal complaint. And as you are aware, your office initiated. You called me. I didn't call you. But I want to get him anyway. And so there needs to be an ironclad agreement. You know, they're talking about some issues here that we're also going to look at the ethical considerations that are concerned with, having, the moral obligation of attorneys who would enter into an agreement that would interfere with and obstruct the administration of justice. No, we're not obstructing justice. All I'm saying to you, Ms. Constand, I'm about to give you about $5 million almost. You need to keep your mouth closed. And if you can't, then we might need to look at some, what do we call those things that start with an R? Say it out loud. Remedies? Remedies. We might need some remedies. Like, I don't want to really say it because my friend gets upset when I talk about $1 million per violation remedies. She likes to represent the Stormy Daniels of the world and all those people. That's the Stormy Daniels attorney. But I need to get her to understand, see, because she's the one who wrote that deposition, that motion, that got the transcript in the record. She's the one who did that. So it was never like really an agreement that had all the bells and whistles that it needed to have for the parties, to bind the parties, to let them know that this is not, there was wiggle room here, just like there was wiggle room with that Stormy Daniels agreement, there was wiggle room here. Okay? So these are problems, and I have to go in the beginning and work these problems, all of these problems out in a way that down the road, Mr. Cosby does not find himself in the position that he's finding himself in, out $3.4 million and about to go to jail. That's crazy. Okay, so now what about, so what is going to be my high expectations that I talked about earlier? For Mr. Cosby. Yes.
The agreement not prosecuted criminally and the immunity.
But his highest expectation, because see, now we're in a civil case that has not yet settled, okay? And at some point, the judge is probably going to order me to give a deposition. What's my highest expectation?
That he doesn't have to speak at all.
That he never speaks. So, immunity, because everybody, Mr. Castor, he's working with the plate and say, yeah, go over there, get him to testify. So I'm going to let him think I'm going to testify so I can get the immunity. I want the immunity, and I don't want to say a word at the same time. The only way I can get the immunity is for him to think I'm going to speak, and that the only way that I can is to plead the fifth. Make everybody think I'm going to plead the fifth in the deposition. So I got to work on getting that immunity. These are things that I need to be thinking about because the case has not settled yet. Okay? All right. I got to think of my high expectation, which, yes, this is high. You know, how the heck am I going to get immunity and not testify? But it's possible. All things are possible. You have to think that. What else? What else is going to be on my high expectation list? We talked about it earlier. I think you kind of talked about it a little bit. What else is on my list?
It all remains confidential.
Okay, in other words, I'm not going to give a deposition. She's not going to give a deposition. She's not going to talk about it to anybody other than the people that have already, her mother, she's talked about it to her mother. She's not going to talk about it to anybody. That's where I'm trying to get to. So this is my high expectation. And then I want to talk about my bottom line. Okay, what is my bottom line? Yes.
That if you do have to testify, it can be used against you.
Okay. Now, okay, that's like one step up from my bottom line. That's okay. I'm going because I do have you know. Yeah. You want to put everything, but then you want to know what your drop dead bottom line is, because you got to be able to know what you're going to do when that happens. If your bottom line does not happen, if you can't get your bottom line, you need to know what you're going to do. And you got to know what the consequences are going to be, and you got to know if your client is ready for the consequences. So my bottom line is what? Yes.
Not going to prison? Or not going to jail?
Okay, but see, look, we're in a civil case now. We've already been told by the DA that he's not going to prosecute. So what's my bottom line right here? Yes, sir. Don't testify. Yes. And if I don't testify, what could that mean? If I don't give a deposition, what could possibly happen? No criminal charges, but I'm talking about in a civil case. If I don't give a deposition, what could possibly happen?
You'll settle for nothing, or the case won't go anywhere.
Meaning what?
That you won't have to pay anything.
I'm talking about if I don't give a deposition, the civil case is still going on. So I haven't settled it yet, and if I don't give the deposition, what could possibly happen?
The case could go all the way to trial and you could still be
right. The case could go to trial. So I have to understand what my bottom line is, and I need to understand what's going to happen if I hold to my bottom line. Okay, so based on what we know now, is there any wiggle room on that bottom line? No. We have to find a way to settle this case early, it seems like. Which means we probably have to pay more money. But we got to get it early before the judge starts breathing down our throat trying to get us to do a deposition. You know, it's going to be the Gloria Allred situation, because she's going to go to the court. She's going to say, Judge, blah, 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 run to the judge, and he, things, the atmosphere is different these days, and so I could see somebody ordering him to testify, okay? So my bottom line, this was never the bottom line, because he gave a deposition. Nobody could see that okay, so a step up from the bottom line is, if I can get the immunity in writing, and in writing the agreement from Castor that he's not going to bring suit. I don't need a press release. He thinks that the press release bound them. It did not. But I'm just letting you all know that there is no way I would ever have let him testify. I would have to go to trial, and if that was the case, I would just have to go to trial, because there's too much at stake. Okay? And so that is the place where once we gather all the information we have now, starting to gather more information to understand where we are, and we may need to brainstorm. Where it says brainstorm, inventing is not deciding. So just because you're brainstorming does not mean that you're making a decision, so it's not going to hurt you. It does not cost you anything to come up with some alternatives that you think could get the case settled with, remembering that we don't want to be threatening to anybody, but to kind of, work through some of the issues. And so this is where I'm starting to get my high expectations. To obtain that criminal immunity, I want Castor's agreement not to prosecute, to settle Constand's civil case without disclosure by Constand or Cosby through written or oral testimony under oath, and to negotiate future confidentiality of the alleged incident. I'm starting to see myself now having to define some things that I may need to define in that agreement going down the road. And then I have my bottom line to settle a Constand civil case without disclosure by Constand or Cosby through. That's my bottom line. And then you want to start looking at your interest. The interest that we talked about earlier. The loss of earning capacity. Once I'm no longer America's dad, that could have an impact on me getting future roles, future jobs, or whatever the case may be, because my professional image has now been damaged. And then that risk of criminal prosecution, which is high dollar. HERS, emotional distress, disruption of life, including the lives of family members that we talked about. Loss of privacy. Now, you talked earlier about opportunities, okay? You know, what I'm talking more about is damage to your professional image, because people know now that you bring her on a college campus and she go around there knowing who, what, you know, she go to everybody's house at night having dinner. What you do on your private time is fine, but, you know, we have a professional environment at the school. You can't, you know, go down with the board of trustees and go to all their house at night for dinner. You know, whatever it is that Bill Cosby did, trust me when I tell you that, you know, he has a problem. But I'm going to tell you that me personally, I don't go to men's house at night for dinner by myself, thinking that I'm just going to go in there and just have dinner and walk out. I have to assume I'm in there by myself. Now, I have to, you know, so these are just, you know, if I'm going to, you know, if I'm working at the university as the head, you know, coach of the basketball team, then, you know, the board or whoever it is going to expect that, you know, I'm not over with Professor whoever and over with the board members and the president of the university having dinner at their house at night. Because there's a line, a professional line. So then, when these facts get out, I'm not going to go into the negotiation threatening her to say, you know, this all will come out. That, you know, you got to walk the line. Walk the line. You got to look at your interests and look at their interests. You know, this could be a loss to her future professional image as well. And then your leverage areas. I have to be able to think about the fact that I have to find a way to brace for that jury trial that might happen. Brace for that jury trial that might happen without providing that testimony. I have to, you know, brace for the consequences that may come from that, because there's going to be testimony. You're going to be, the media is going to, you know, all these kinds of things. Can I approve this? Yes. Leverage favors who? I would say, really, it does not favor Bill Cosby. This civil case will tarnish his image, and what's even more, this is the part right here that I don't think was given the amount of weight that it needed to be given, and that is that if he ever has a criminal trial, he could go to jail. And then over here on this side, to compel Cosby testimony under oath and or provide testimony under oath, Constand, with the risk of it being disclosed publicly. You don't want to threaten, but you just want to just remind her in a nice way. Counsel, you may just want to remind your client, just, you know, that her interest could be negatively impacted with the public trial as well. And then just think, Bill Cosby is so well known in the community that he's famous, that, the jury pool is going to be made up of these people who could favor him more than your client. You could go through all of this, have the tarnishment of your image, your public facts, your facts coming out in the public, and you could lose. You don't threaten, you just remind in a nice way. And throughout that negotiation, I am building rapport with opposing counsel. Hey girl, how you doing? Just call you up on the phone. How you doing, counsel? How's Andrea? You can't be, you can't go in stank face all the time. You can't just be like, you have to go in, hey, hi. You have to be ready to settle. You have to build the rapport through, your communications in email, on the telephone, these types of things. Okay. All right. I'm going to have to move on past this, you all, but you get the idea. So I want you all to develop this. Let me let you. I also talk about the creativity part of it. You may have, Bill Cosby, some friends at different universities who might be able to, you put in a good word for Miss Constand on the flag. You just kind of like on the down low. See, sweeten the pot a little bit. I will give you this almost $5 million plus. You might be able to, find somebody who has a very high profile position in the basketball program at another university. You have to be creative. And then, you start to work through the analysis of mine and theirs and your counter arguments. As per Castle, there is not enough evidence to prove. This is where you are going to get your objective standards, okay? So where are we going to find those in our materials? The materials that we looked at. And it's obviously not all of you were able to get to everything, but maybe somebody was able to get to some other parts. Where are we going to get that? The objective standards.
The objective standards of the case against him?
Of any part of the case. Because remember in your slides where we talked about, and these are the ones that we talked about where the objective standards will come from, like what? The law. And these are also in your slides that are in your week 10 materials. These are the same. I mean, it's just in a different organization. The law. So in your materials, what do we have that points any of that out? I'm just trying to see if anybody went past any of.
Maybe the motion to dismiss.
Okay, what about it? What parts of it?
It would include all the legal basis.
Which ones? Like what page are you looking at?
Oh, I have not looked at it. So I don't know specifically.
Okay.
Where it would be.
So you didn't go through some of it? So when you get a chance, I want you all to work through some of these materials because we're going to work on this project now. But you see here where it talks about the standards that you need for immunity, we're being able to look back now, in hindsight. But this gives the law on what you need for immunity. And you do that objectively for us, using the law. There's some other types of negotiations that we will work on where you might need an appraiser or an accountant to work through the objective standards. And then I do want to talk a little bit about this, your competitive negotiators, your collaborative negotiations. You want to not, you can't, you can't be like a win-lose, zero-sum game type of a deal. You have to be someone who wants to collaborate and work on problem-solving the interests of both parties if you're going to be successful in that negotiation. Because if you poison the well early on in the relationship part of it, you'll never get the case settled. The other part will just never settle the case with you because they just don't trust you, they don't like you. You have to be able to have a relationship